Good evening. My name is Dominic Calhoun, and I serve as the Vice President for Membership for the National Bar Association. I want to welcome you all to this first event of the Economic Empowerment Institute, to which I also serve as the chairperson. The Economic Empowerment Institute is a division within, or committee within, the National Bar Association dedicated to providing individuals throughout the country with economic empowerment and information so that they can maximize the opportunities. And so tonight is our first webinar that we're going to host and provide throughout the nation. And so this is going to be recorded, and we are proud to have a number of members of the National Bar Association here today, as well as members who are going to share some expertise within their profession. And so tonight, if you are a small business owner, and we know all of the pandemics that we are facing throughout this nation, we hope that the information that we're going to provide is going to be of resource to you. And so with our panelists prepared that we have here today, not only talking about from contract law to IP and to issues within business loans, we hope that the information provided by our experts will provide you some relief and hope for the future. And without that, without any further ado, I want to go ahead and get our program started. Tonight, we have a number of panelists from all across the country. And before we get into that, I want to introduce you to your host for this evening. Ms. Genya Grant is a member of the National Bar Association, and she's also the Region 2 Director. She practices in the area of business law, real estate, and sports entertainment and intellectual property. She began her career as an attorney with an entertainment and litigation firm, where she worked on employment and discrimination cases and high-profile entertainment litigation and music publishing matters. Building on her blended experience of transactional work and litigation, Ms. Grant opened her own firm and initially representing clients in a multitude of real estate transactions, bankruptcy, labor-related administrative hearings, and arbitrations. While developing an entertainment practice consisting of book publishing, sports, film, TV production, and music, she has handled a mix of litigation and transaction law, providing advice and counsel to small businesses on formation and startup, mergers and acquisitions, real estate, contracts and copyright and trademark and IP licensing, with an emphasis on contract negotiation. She has served as counsel to several nonprofit corporations, as in-house counsel and outside counsel, counseling matters on such as corporate governance, employment, technology, construction, compliance, commercial contracting, and IP. And she has drafted and negotiated a multitude of contracts, primarily within the creative industries. With that, and without further ado, Ms. Grant, take it away. I think you're muted, Ms. Grant.
My apologies. Thank you so very much, Vice President Calhoun. It is my pleasure to chair this subcommittee on small business, and I look forward to a very informative and lively discussion. We have several panelists who are very, very experienced in their own right in small business topics, intellectual property, and overall business law. And we look forward to bringing this presentation to you this evening. I would like to introduce our esteemed panelists to you at this time. We have Jennifer Fisher. Jennifer Fisher is a Boeing executive. She serves as intellectual property counsel for Boeing's military and space programs, including the autonomous systems, commercial derivative aircraft, and space and launch business in both Boeing's defense, space and security and global services units. She also counsels missions and payloads in Liquid Robotics, Inc., both in the autonomous systems group. During her tenure with Boeing, she has also served as responsible attorney for Spectral Lab, which is the space industry's leading supplier of solar cells and panels, compliance counsel to Boeing with respect to the United Launch Alliance, and as program counsel supporting Boeing's commercial satellite systems businesses, where she was responsible for supporting business development and contract teams pursuing international commercial satellite construction and related contracts, including leading negotiation teams in Saudi Arabia and Israel. We also have Marisha Bay Taylor. Marisha Bay Taylor, the founding partner of the law office of Marisha Bay Taylor, is an intellectual property attorney who works closely with Black creatives to bring their brands to the utmost potential. He specializes in mechanisms that allow creatives to protect their creative capital, such as copyright, trademark, and non-disclosure agreements. Ms. Bay Taylor's clients include social media influencers, fashion designers, graphic designers, photographers, screenwriters, musicians, and other well-known talent. Ms. Bay Taylor sits on the board of Black Women Lawyers of Los Angeles and is very happy to join us today. Next, we have Caleb Green. Caleb Green is an associate in the Dickinson Wright Las Vegas office. His primary areas of practice include intellectual property, government affairs, immigration, and cybersecurity and data protection matters. Namely, Caleb's experience revolves on trademark prosecution, intellectual property, litigation, and enforcement, deportation defense, employment, immigration, government affairs, and business matters. Prior to law school, Caleb worked as an information technology professional and network engineer for the Office of Information Technology at the University of Nevada, Las Vegas. And we also have Shahara Wright mentioned. Shahara is the award-winning author of From Entrepreneur to CEO and the creator of the CEO Collaboration Circle, Single Mom CEO, and Business Done Right. As a business strategist and business law attorney, her strategies and proven methodologies have transformed the way small business owners, engineers, and CEOs reduce legal liabilities and increase their bottom line. Shahara founded the Wright Firm, PLLC, over 20 years ago when she couldn't find a law firm that matched her schedule as a single mom. From a young age, she knew it was possible for entrepreneurs, especially single moms, to build a successful business their way. After that humble start, Shahara quickly developed the road to CEO success to help CEOs of small and medium-sized companies enhance operations and creative strategic change. Shahara's success was just getting started as her firm began assisting brands with product development, bringing products from mere concept to a fully developed and manufactured brand. Small and medium-sized businesses were seeing reduced operation costs of 20% and increased profitability by as much as 30%. Of course, Shahara's strategies aren't just for small and mid-sized companies. She's helped entrepreneurs at all levels how to build a sustainable business, protect it, and make more money doing the work that they love. So there is our esteemed panel for this evening, and it's a pleasure to have you all. And so I'm ready to dive right into our discussion. And our first portion of our presentation tonight is going to deal with business formation and commercial contracting, which will be presented by Shahara Wright. So Shahara, tell us and all of the business owners why choosing the appropriate entity is so important.
Well, I mean, it's really important because it outlines what your company is going to be able to do and the direction it's going to go next. So I think the most important thing to understand and to know is that there are a bunch of opportunities and options, and you don't have to just pick just one, and you don't have to just LLC it. There's a lot of different options out there, and not necessarily one is not necessarily better than the other. It really just depends on your business and the direction that you're going.
Okay, so, in terms of the types of entities, is there one that's better than others? I know it depends on the business that you have and maybe some tax considerations. Can you just talk a little bit more about the different types of entities?
Yeah, and I had a slide. I don't know if it's up. There it is. You can kind of skip to the one about corporations. That would be good going down. I think it's the next 2 slides. Right before it. There we go. Yeah, there we go. So just for people to know that there's more than, obviously there's so many different business entities. There's lots of different ones. These are just a kind of a sampling of much ones. The ones that most people ask me about have to do with corporations and limited liability companies. So in my presentation, I'm going to talk about those two entities. So you can move on to the next slide. So a corporation is just kind of what you think. It's just a legal entity. The legal entity really kind of creates a person. So sometimes you will hear in legal conversations about person, and person is included in a corporation. A corporation is a person. So once this legal entity is created, it creates someone separate and apart from the individual owners. And I like to give the example of thinking about large corporations like a McDonald's, where you have these various different roles that are, I like to call a three-tiered management system that you will experience when dealing with a corporation. So you have the shareholders who are the owners, like McDonald's, where shares, obviously buy and sell their shares. They get off of the ownership of it, but they may deal with the day-to-day or have any over the organization. That do. The board of directors oversee the organization, kind of their strategic ideas and thoughts about where they want to see the organization go, and they kind of work on behalf of the shareholders to that the shareholders are able to make money. Sometimes they're the same as the shareholders, sometimes they're not. So that can be happening in a corporation. And then you have officers, which are your CFOs, your COOs, your CIOs, anybody in the C-suite, and whatever C you want to put before it. They're usually employees, and that's what that are. So you take that large company idea and you kind of bring it down to maybe one or two people that are in the corporations. They can these, but they serve different functions. It's a much more formal structure. Each of these roles have to exist, but the good thing is that and apart from the individual, so that's what creates protection, because the corporation is acting. And then a corporation is really good for fundraising, meaning if you're needing to raise significant amount of dollars and bring in investors to help fund your business, a corporation is a really good vehicle in order to do that. To the next slide. The next question I get, okay, do I need a C corporation or an S corporation? And I always have to tell people, okay, these are tax designations. A corporation is a corporation is a corporation. But how they're taxed varies. A corporation has two options in being taxed. The first one is this, we call default, meaning as soon as you create and then you file for your EIN, the IRS is automatically going to treat you as a C corporation. In this, that the company files its tax return, it will pay taxes that it makes. And then if that corporation gives out dividends, gives out money to its shareholders for the fact that they are actually shareholders, then the shareholders are going to pay taxes on that money that they are given. So if the $4,000 is paying taxes on that $40,000, if it gets $2,000 each to its shareholders, the shareholders are going to pay taxes on that $2,000. That creates what we call double taxation. So you may have heard that term. Does. Next slide. Next one will be S corporation. Again, is a tax election, and has to do with once you ask to as a S corporation. It's a different form that you have to fill out to be taxed as a S corporation. Doesn't pay taxes, but it passes shareholders. So what you will see happen there is that makes $40,000 profit, then you have two shareholders, 20,000 to one, 20,000 to the other, and they pay taxes on their individual tax rate. So then that's what we call a pass-through tax, meaning that it comes from the corporation to the individual shareholders, and it doesn't matter how much they receive, they're going to pay taxes on the profits of the corporation. Next slide. Next, we have a limited liability company. And of course, this is the one that I know a lot of people always ask me about, always say that they want. They, you know, people just say, just create an LLC and just make an LLC. And sometimes it's a very good vehicle for, especially for small businesses. Unlike a corporation, you have kind of a flexible management system. You have members, which are similar to shareholders. They are the owners of the LLC. You can have managers. You don't have to have managers. Managers function like the board of directors in a corporation. And then, of course, you can have officers. Again, your C-suite type people, president or secretary or whatever you want to call them. These are usually employed people that work for the corporation, for the LLC that carry out the day-to-day. So in this limited liability company, you can have a member managed or a manager managed entity. And those are options that you have when you first set it up, and that's how you're going to run your company. So it gives you a lot of flexibility, which is really great for small business owners. Next slide. And last but not least, on the LLC, another good thing in the flexibility is that you have lots of different tax choices depending upon how the entity is set up. So you can be taxed as a sole proprietorship, a partnership, or S corporation, or C corporation. And I always say, I know probably some of you are going, well, which one should I choose? I always tell people to talk to their accountant or the CPA that they trust and know, to talk about their business and find out which tax method should be done for their business, because they do have different consequences and significance in which you're going through. All right, next slide. So now I want to talk about some HR issues. I know I got a lot of different stuff I'm talking about, but I wanted to give you guys an overview of some different things that you need to consider in terms of, business and business operations. You can go to the next slide.
So, Shahara, before
yes.
we segue into the HR, I just wanted to ask a question. So,
Sure.
Once you've chosen your entity, you've talked with your accountant, you've perhaps consulted a lawyer, and you've formed the entity. Are there other documents? There are usually other documents that are required, i.e., an operating agreement or governing documents that kind of go with choosing the correct entity. And so I just wanted you to just touch on that just very, very briefly.
Sure. Those are what I call backup documents. So you get your initial formation, you get your EIN, you can open your bank account with those. And I think a lot of times people forget that for corporations, you should have your bylaws, you should have minutes. And the same thing with limited liability companies, you should have an operating agreement. I'm a big believer in minutes for LLCs too. There's some argument about whether or not they need them or not, but I believe you should have it to show that the entity is separate and apart from the individuals. So these are things that you should have. If you sometimes people will have other documents in terms of what they need from the state, and that may vary depending upon whether or not you need a sales tax forms or other things that may go along with the profession or what you're doing. So those may add on to what we call your backup documents. But it's very important to have, your bylaws, your company agreement, minutes, those things that you need in order to show that that entity is separate and apart from the individuals.
And if you're seeking business financing, aren't those some of the documents that would be required that the mortgage, that the lender would require you to submit?
Absolutely, yes.
Okay.
So for those of you that are looking, obviously, to have your business, we talk about human resources, and human resources is just a method in which you are able to carry out your business. So using a person, a human, to carry out what you need to get your business. And there's various ways to do that. The two most common ways is using an independent contractor or having an employee. And I think it's important to understand the difference between the two, because they have significant tax consequences, and there can be penalties when you don't correctly classify them, whether you have an independent contractor or an employee. So independent contractor is somebody who contracts to do a piece of work according to his or her own methods, subject to client's control only as to the end product or final result. So if you think about what it really is, an independent contractor, they are independent from your particular business. They are able to make decisions about how they want to carry out the work. The only thing that you're going to say to them is that, I want this result, but they decide how that result is going to be achieved. So that's really important to know. You can go to the next slide. Next is an employee. Employee is a person in the service of another where the employer has the power or right to control and direct the person. So really what that means, just as he says, is you're an employee, you are subject to what your employer wants and how they want things to be done. And I know that we've all kind of been in that place where somebody wants a spreadsheet to look a kind of way and it has to have certain dots and, bells and whistles. And you wonder whether or not you need this and whether or not it makes sense. But when you're in an employee role, you have to do things the way your employer wants it. So there's a kind of a level of control that's there that doesn't exist for an independent contractor. Next slide. So IRS for years, over 20 years, maybe 30 years at this point, has had what they call a 20-point test. This 20-point test is kind of like categories and thoughts about what is determinative of an independent contractor versus an employee. And the reason why this matters is because obviously, like I said before, there's tax consequences and depending upon which is which that have to do not only with unemployment, employment tax, overtime, how you pay, the rate of pay, all of that kind of stuff, minimum wage that goes into it. So over the years, the IRS has kind of changed their model and how they look at things. Those 20 points still exist, but they categorize them differently. And they created 3 categories of control, which are behavioral, financial, and type of relationship. You can go to the next slide. So in behavioral control, this is kind of coming from the standpoint of an employee. There's different things that you want to look at, right? You look at the type of instruction. What kind of instruction is the employer giving to the employee? How detailed is it? How specific is it? Those are kinds of things that indicate behavioral control. Is there an evaluation system that's in place that requires for employees to have to adhere to and say and be judged against? Training, how much training or what type of training is put in place to train the worker about how to do their job and what to do. And then regular wages. And regular wages kind of mean, are they paid hourly? Are they paid weekly? How are they getting paid in a consistent manner that makes it look like they are an employee? And I want to say that it's not like you take one of these things and it's bam, you're an employee. It's the totality of the circumstances of what's going on that the IRS and other governmental agencies will look at to make a determination about whether or not this person is an actual employee. The next slide, please. So financial control, and we're going to look at this from the point of view of an independent contractor. As an independent contractor, you have the ability to realize profit or loss. You have a significant investment, and the investment really is into your own individual business, not into the client. So you're putting into your business what you need to be able to function. You may have unreimbursed expenses, and those unreimbursed expenses really have to do with you may have software that you use for your clients. You may have other equipment that you use that you can't actually directly bill your clients for. So those are unreimbursed expenses. You're free to seek out other business opportunities. So you're not beholden to this one company, or they don't control your schedule. So they can't tell you that you can't work between 9 and 5 because you have to be completely dedicated to this company. So you have the freedom to seek out other business and other opportunities. And then you're paid by the project. And so there's an outcome that's expected or a certain amount of things that you're supposed to do, and you're paid for that. And that kind of gives you the financial control, which makes it seem like more of an independent contractor. Next slide. And then lastly, in terms of this kind of 20-point test, is the type of relationship. You have an employee and you probably have benefits. This person kind of puts out the key activities of the business and the roles and what it does. And so that indicates more of an employee. With an independent contractor, you should have a written contract. And then the term of the relationship is intended to be short or for a specific period of time. Now, I know that there are some contract relationships that last over time, and that's okay. But, you know, that doesn't say all in by itself that it becomes an employee, but there is a specific limit or portion that this particular person is moving on. So that's for our HR section. And I just wanted to kind of go through a couple of contracts that I think you guys should have as well. If you can go to the next slide, actually next one after that. So these are some business contracts that I really think are important for business owners to know and to understand. So if you're a professional service organization, you should have a contract for your clients. Have a clear contract about the services that you're providing, especially if it's in a professional service like a lawyer or CPA or, you know, something like that, where you want to make sure that those terms are lined up with what your profession requires or, you know, association requires to do. And you want to make sure that it handles things like work product and copyrights, which I know people are going to be talking about later on today, but you want to make sure that those things are covered. We talked about an independent contractor and what that is. Sometimes contractors have their own contract because it's their service and so they have something to fill out, but sometimes you need to have an independent contractor agreement because when you're bringing on somebody for a specific project or specific thing, you need to have your own agreement to ensure that it's clear about what their expectations are, what you're paying for, that it's not creating an employment relationship, and that there's defined quality about what's happening. And then lease agreements, which could be over equipment or real estate, those types of things, you want to make sure that you have a clear written agreement. Next slide. And then last but not least, this is what we call our restrictive covenants, where you have your non-disclosure agreement, your non-solicitation agreement, your non-compete agreement. And these kind of agreements kind of vary in what's required, but your non-disclosure is really a confidentiality that protects the privacy of your clients, also protects, you know, your work product, the things that you're doing inside your business so that somebody else is not taking your things and telling everybody about what you're doing. A non-solicitation agreement really kind of controls people from taking your employees or your clients and taking resources out of human resources or clients out of your business. And then the non-compete really, especially with independent contractors, keeps somebody from coming into your business, kind of learning all about what you do, and then duplicating that and competing with you directly. And so these are some agreements that small businesses should consider and know about and be able to move forward. So I know that I gave you guys a whole lot of information all at once, but these are just some tidbits that I think all new businesses or existing businesses should have and be ready to deal with.
Thank you, Shahara. That was a wealth of information. One thing that I wanted to ask you to just touch on was just perhaps maybe some pitfalls or with independent contractor agreements and perhaps some terms that are really important. You mentioned not creating, obviously, an employment relationship. Actually, in terms of the non-compete agreement, that's actually where I meant to go. Talk about in terms of forcibility and scope. You know, how long can someone enforce a non-compete? And, you know, does it mean that they can't compete anywhere with you? And, you know, does it mean forever and perpetuity? If you can just touch on that, just so that the business owner is protected.
Sure. So with non-competes, they're very, very tricky. And they're kind of a creature of state law. And they may not mean much to other people, but, you know, it really depends upon where the person is. So for those of us that deal with people in other states and other places, you know, it depends on where that person is. So there are states that don't recognize non-competes, and I don't care what, for any reason. That's California, Montana, and Oklahoma don't recognize them. They're not enforceable. So if you're in those states or your person is in that state, I'm sorry, you can't use them. And then you want to make sure that it's tailored. Now, you shouldn't just be handing out, non-competes like they're donuts, right? Like these needs to be something that's very specific and for reasons that you are concerned. So I like to use a case of like a personal trainer, and you bringing in another personal trainer to help deal with your clients, and then that personal trainer goes and creates their own studio right next door to you, and then they're competing directly with you with your clients. So you can limit that for years, for maybe a year, max maybe 2 years, depending upon the nature of the relationship. Geographic, you can't say throughout the whole entire US. If somebody else goes to Dallas and I'm in Houston, so if they go to Dallas and create their studio, they're not really competing with you. So you need to have a radius in which that is. And I think for larger cities, it's going to be much more difficult to do, because you might have to do like a 15-mile radius or 20-mile radius. But if you're in a small town where there's like very few people, you can probably say the city or the county or something like that. It really kind of depends. And then you have to really have, it needs to be tied to something, right? Not just because they come and they work for you and do some things like that, but it needs to be tied to, they're providing the service. They have some kind of connection, a high level connection that they're having, being privy to, that if they actually went out and competed with you, and it would really cause a problem. You don't want to give this, if you have a studio and somebody that's coming to clean your studios, you don't want to create a non-compete for that, because that has nothing to do with the connection of the job.
Thank you so very much. Okay, so next we're going to transition to protecting a business's intellectual property. And so we're going to talk a little bit about the various types of intellectual properties and copyrights, patents, trademarks, trade secrets. And Caleb Green is up next to give us that overview. So Caleb, so can you just talk about the differences between copyrights, trademarks, patents? Some business owners, sometimes we all get questions about, well, I have a song and I have a band, and I would like to trademark my name, and I'd like to copyright this dance step. And sometimes it's confusing because they're often the elements of each, because they all deal with assets that are very important to our businesses. It's easy to get them confused. So if you could just give us an overview.
Of course. Thanks, Ms. Grant. Yeah, as far as intellectual property is concerned, many of you may have heard the term IP or intellectual property, and you may not necessarily know what that is. If we want to move to the next slide. But effectively, intellectual property is basically intangible creations of human intellect that may be protected under United States federal or state laws. So as you mentioned, we have 4 major areas of intellectual property. That's your copyright, your trademark, your patents, and your trade secrets. So these are effectively your 4 major areas, and kind of the difference between the 4. You may hear some people use them loosely and refer to something as, oh, I'm trying to get a copyright on this or a trademark on this. But to really give you a better understanding, really need to define what subject matter each of these cover. So copyright is effectively provides protection for creative works that are original and captured in some tangible medium by a human author. So some examples of this are, as you mentioned, you talked about musical works, sound recordings, artistic works such as pictorial or graphical designs.
Yes, and I probably threw some wrong terms out there to show how confusing it might be. So for those who are watching, if you heard me talking about trademarking a song, if I did say that, if that was intentional to show that sometimes we can all get those things confused. Songs go with copyright. So go ahead.
Of course. No, and that's a great point. A lot of people get that. Journalists do it all the time, and it drives me nuts. I'm not sure if you all remember LeBron James, and he filed a trademark application for Taco Tuesday, and I was reading articles that said he's trying to patent the name and he's trying to, copyright the name. And the IP lawyer in me was getting frustrated because but it's common. People do get these mixed up because they just don't know. But copyright effectively is limited to these creative works, whereas trademarks are symbols, designs, even sounds or slogans and names that go towards distinguishing goods and services in the marketplace. So that is very distinct from copyright, because copyright does not protect short phrases or short slogans, things such as, "Just do it" by Nike, right? That alone isn't a creative work and something that would be subject to copyright protection, but you could protect it with trademark protection. Patents is another one. This is essentially a property right in an idea, an invention, a business method or process. This is where your ideas and your concepts typically fall. And you can, through the USPTO, the patent office, you can get a patent issued on your idea and stop people from selling or offering to sell or exercising your particular protected invention or process. And the last thing is trade secrets. Trade secrets essentially is any type of valuable information you have that has some kind of commercial value, and you take reasonable steps to basically protect it. We heard earlier from Ms. Wright earlier, she talked about using non-competes in non-disclosure agreements. Those are some ways that you can protect trade secrets, such as recipes, algorithms, things such as that. So that's essentially what we have as far as an overview on IP. And I'll focus a little bit here on trademarks if you want to move to the next slide.
Before we do that,
go ahead.
Take my indulgence for a second, because I see that our NBA president, C.K. Hoffler, has joined us. And so I just wanted to take a moment to just give her the floor so that she can welcome us all here today.
Well, thank you so much. Thank you so much. I love being amongst the leaders of the National Bar Association, because the talent and our members, the leadership, the talent, the skill, the training always just mesmerizes me. And so I was listening to, I think it was Caleb Green, talk about intellectual property. Now, I've litigated a little bit of intellectual property, but I really could not advise businesses on it. And so I want to say thank you for allowing me to address you all. Thank you and welcome to the National Bar Association, this webinar. I'm apologizing for being late. I had literally 3 webinars at the same time. And even though this one was a little bit later, the second webinar bled over to this one. And so I was rushing and I left them because I wanted to be here. I wanted to say how much I appreciate those who put this together. And when you talk about maximizing your finances, that means different things to different people. As a lawyer who's practiced now for almost 34 years, it meant something different to me when I started in 1987, maximizing my finances. Because in 1987, if you came out and you were making $60,000, you had hit the jackpot. Nobody could tell you anything in 1987. I know today there are many that come out making $200,000 at a minimum, plus bonuses. So the world has changed, but of course the lifestyle has changed. So at the National Bar, what we hope to do is to level the playing field with knowledge. Knowledge is power, information is power, and being able to talk to people at all different stages of their careers about financial planning, about maximizing your productivity and how you can take yourself to the next level. So in closing, as we operate and navigate through 3 pandemics, the actual healthcare pandemic that is plaguing this country and the world, I say, be vigilant. Be vigilant with your health and with your finances. As we deal with police brutality, be vigilant and remember that we can't turn our backs on the issues of police brutality, because literally it impacts each and every one of us. And if it hasn't hit you home yet, it will. But even if it doesn't, as officers of the court, we have a duty to our community to try to make it better. And then voter suppression, we just came off of the most incredible presidential elections that we've seen in a long time because of all the issues that we saw and all the racial dynamics, and the most dynamic Georgia Senate runoff elections that we probably will see in our lifetime. My goodness, voter suppression everywhere, every way, every how. But we saw the magnificent role that lawyers can play in being change agents. And the National Bar stood in the front of the line as a change agent in protecting people's right to vote. So in closing, when it comes to your finance, maximizing your potential, being the best that you can be, no matter what type of work you do, be a social justice engineer and recognize that your communities depend on you. They rely on you. They're looking for your advice and counsel. And you cannot take it lightly, because whether you want to be or not, you're an opinion leader, and you're a leader because of your license and the color of your skin. Thank you.
Thank you so much, President Hoffler. Thank you for joining us, and thank you for those words of wisdom. It's because of your leadership and your foresight that we're able to be here and be a voice and resource to our community. So thank you again. So we're going to transition back into our trademark presentation. So Caleb, you were picking up on trademark registration. That's where we left off.
Yes, and this is very apropos to what President Hoffler was just saying in maximizing your finances. It's very important to understand the differences between IP, because the last thing you want to do is spend time, resources, investing in your brand, investing in your business, investing in a registration, the USPTO, only to find out if someone else has used that mark. There's some issue with the basic structure of your mark, so that you can't actually maximize all the intellectual property out of your mark or your brand. So one of the first things I just wanted to bring up is that trademark rights manifest upon use in commerce. So the moment you start using a mark in commerce, effectively you have what's called common law rights. At common law, you have rights in that particular mark. Now, however, the scope will be limited to wherever that trademark owner uses their mark. So for example, if you don't have a trademark registration with the USPTO, you may not get that national scope of protection that you would have otherwise. So that's something to keep in mind. But it's also important to know, because you don't want to infringe on someone else's rights. You don't want to, someone else may be using that particular mark. So things that are very wise for you to do is seek out attorneys, seek out counsel in order to, for them to do what's called trademark clearance searches, to give you an idea of not only is your mark likely to be registered if you filed a federal trademark registration or a state trademark registration, but also what's your likelihood of infringement. Because again, you don't want to spend all this time and resources into building your brand only to have to go back and not only redo your website, but also get redo packaging. All that can be very costly to a business. And so you just want to keep that in mind. I'll make a quick note on the differences between federal and state registration. At the federal level, there are a lot of benefits, as I've listed there: national scope of protection, presumption of ownership, notice of ownership. There's also limitation of classification of goods and services. So when you file a trademark application, you will be identifying what kind of class of goods or what kind of goods you're going to be using this mark for in commerce. So you do want to keep that in mind, because it doesn't just give you a broad, trademark registration doesn't just give you a broad right to use the mark on any and everything. It's tailored to specific goods that you identify. And state registrations, those can also be helpful in places where you may not get federal registration. Things such as if you're running, let's say, a cannabis business, and whereas at the USPTO, they will not allow you to or will not issue a registration for certain cannabis or hemp related products. But in states where they have legalized recreational use, that also may be advantageous. And then lastly, in some states like my state, Nevada, where you have a state registration, attorney's fees you're entitled to attorney's fees if someone infringes. So that's another level of added layer of protection that you might want to consider. And then we'll go to the last slide and I'll pass it along to my colleagues here. but I'll talk briefly about common trademark pitfalls. As I mentioned, failure to conduct a trademark clearance search can be, I've seen many companies file for a trademark application, not get it, only to have to rebrand their entire business because there was another mark out there, or the mark that they want was wasn't sufficient to the USPTO standards. Improper use of another's trademark. You want to be careful in using someone else's mark. You want to be careful. Again, this goes back to doing a trademark clearance search. That's very important. And last two things I'll talk about, I mentioned limitation of the classes of goods and services. You also want to be careful, especially in COVID, that you're still using your mark in commerce. As I mentioned, rights are based upon how long you're using your mark in commerce. So especially with things you want to consider with COVID, I know that states were shutting down businesses. You want to be certain that you're continuing your commerce, whether it's online, whether it's in some other form of medium or infrastructure, because that also may be a threat to your existing trademark rights if you were to stop using your particular mark in commerce. So that's a little trademark law in a nutshell for you.
So you mentioned, thank you, Caleb. So you mentioned trademark clearance search and the importance of it, and obviously how it can impact your business if you fail to conduct one. How easy is it to do a search, and do you need to use a service, and how simple can the search be in order for you to be protected? If you could just explain just a little bit about how to conduct a proper search.
Sure. Yeah, it kind of depends on the mark and what's out there. So typically what we've done in the past, what we do is we have a service that we use when we're conducting a search, and it provides us a robust list of what's out there as far as the federal registration, not just registrations, but also applications. What have people filed that have not necessarily issued to trademark registrations? Also gives us a list of state trademark registrations. And then we also use other tools. The internet itself is a great tool. The trademark test is also a great tool that people use. We use it as well. I've had some clients who have done their own trademark searches, and we put an application together, and it went through simple and clean. We've had others where they have not, and we've had problems. We've had office action responses. So in many cases, the general rule, I'm always going to advise people to you may want to talk to an attorney, an IP attorney who has done these trademark searches before, because then they can give you a better idea of what is out there. They know where to look. It's not enough just to type in the name of your particular mark. You also need to look at other, the transposition of those words, similar words. That the USPTO will likely cite against you if they find it. And lastly, again, the USPTO, is only looking at, when they're talking about registration, what's on the principal register, what trademark applications actually exist. They're not going to look at common law use. So that's also another aspect that attorneys also can provide some analysis on, and giving you an idea of not only what's your likelihood of a registration actually materializing, but also what's your risk of infringement.
And so, thank you, that trademark is based on use. What are some of the ways in which that a business owner would demonstrate, or what kind of documentation should they keep or preserve so that they're able to prove use?
So typically, to prove use, you guys have to prove that you're using it in commerce. Things such as like pre-orders or crowdfunding, that typically isn't going to be enough. There needs to be some exchange. I will say that there is a kind of an exception to this. If you do want to file at the USPTO what's called an intent to use trademark application, that will allow you to file a trademark application and take the benefit of the date of that filing before you actually start using that mark in commerce. So that can also be very useful for you. Now, there are limitations. You can get extensions, but typically, as long as you provide some kind of proof within 6 months that you are using that mark in commerce, then that is kind of a way that you can kind of get around that. But generally, the general rule is you want to show some kind of exchange of goods and services in commerce, things such as pre-orders, promotional materials, crowdfunding, that might not be enough.
Okay, thank you. Thank you so very much for that overview of intellectual property and also some of the pitfalls that business owners could possibly face. Next, we are going to transition into IP. I mean, we've had an overview. We've talked about the differences. We've talked about some pitfalls, but the big elephant in the room that we have not talked about yet are social media, and also contracting, and just overall. I mean, why do we care, or why should we care so much about IP? Well, the good news is that Jennifer Fisher is up next to answer many of those questions. So I welcome Jennifer to the floor.
Thank you. So you have your great business idea. You are either already have a business or you are ready to start one, and you're all excited. And then here comes Wells Fargo and the National Bar Association telling you all this stuff about IP. You're ready to see where the money resides, and we're putting a damper on you moving ahead. So next slide, please. So why should you care about IP? Well, as Caleb just talked about, you might have a unique business name. For example, a lot of people, when they come to Los Angeles, where I live, they want to go to Roscoe's Chicken and Waffles. If another business was able to set up a business called Roscoe's, you're going to be going to a place with maybe not as good chicken and definitely not as delicious waffles. Similarly, a lot of small businesses that I see now, often advertising through social media, are small restaurant pop-ups or even established brick and mortar restaurants. And they have a popular dish and a special way they make it. If you hire someone as a chef and then they leave and they go open another restaurant, which we've had happen in Los Angeles too. Soul Food Restaurant had some great recipes. One of their cooks went and opened his own version and was making the same recipes. You want to have agreements where your employees are not allowed to do that. You may create inventions. You may have a technology company. Your employees may create ideas. The main thing is that IP, that's the things that you think of. That's your passion. That's why you created this business and why your business is different from everyone else. You also need tools to run your business. You need software licenses. You need computers. You need apps. And all of those things have license requirements and restrictions on how you can use them. The other place where IP is especially critical is in your advertising, particularly making sure that you're not infringing other people's marks and other people's content. And I'll talk a little bit about that more later. And the other place where you need your IP protected is when you want to share it. So you have something valuable, it's your idea, it's great, it's fantastic, and you want to share it with a potential supplier, with a partner, with a customer, with employees. You need contracts to protect that structure. Next slide, please. So there's a lot of different contracts from an IP perspective for a new or growing business. A primary type are license agreements or other agreements that grant rights. And basically a license is the owner of the IP, the licensor, or the owner of the rights is telling you how you can use their intellectual property. And if you're the owner, you're telling other people how they can use your intellectual property. So some typical licenses that a small or growing businesses would need are software licenses. And that's your basic software. And it may not even be special software. If you have a certain types of business may need specialty software, but this could just be your day-to-day office software, such as Microsoft Office and Outlook. You're used to maybe buying that for yourself personally and licensing it. But that license agreement doesn't allow you to then, say you have a small office and you have 3 people that work there. You may not all be allowed to use that same copy of that software, and you could face penalties if you do so. So you want to know how you can use it, the number of users you can have, where you can put it, who can use it. Music is a big one. So if you have a business, if you have a barbershop and you're playing business, if you have a nightclub or a restaurant and you're playing music in the background, or if you're posting content You probably see a lot of time on social media. People will post a video and they'll post this sentence that says, "I do not own the rights to this music." That doesn't protect them from an infringement action, but they're doing that because they probably got a notice from Facebook or Instagram when they posted it that said, this looks like you're posting somebody's music that may be protected by copyright. Do you own this music? And when they click no and put that sentence, Facebook or Instagram allows them to post it, but it won't protect you from a copyright action. So particularly, we know that your business is going to be successful. So when you're a small business, maybe no one will notice, but when you start getting more followers, you're getting 100,000 followers, maybe you're getting verified on Instagram. If you have a lot of content where you've been using different artists' music without having rights to do so, that can put you at a potential of being subject to an infringement suit. Same with images and trademarks and logos. If you are taking some content, just because something is on the internet doesn't mean it's not protected by copyright. So as soon as somebody creates something, and that means if they write an article, if they take a photograph, copyright exists as soon as that's created. And just because it's posted on the internet doesn't mean it's not protected, just because it's available and accessible. And so these are things that you will need licenses or at least a permission to use. And there's a lot of things that people will allow you to use just if you give them credit, but they have to agree that that's the way they're going to allow you to use it. Similarly, once you're starting your business, you may need other people to use your services or products or your content. You may have a carpet cleaning business and you have some independent contractors who you're allowing to put your trademark, a big, sticker on the side of their van that has your trademark and your logo. You want to make sure they only have a right to use it for your business and for your purposes. So it works both ways. And earlier on, we talked about non-disclosure and confidentiality agreements. Those are equally important. Anytime you tell somebody something, unless you have them sign an agreement that says they will not share it with somebody else, you're going to have a problem and they potentially can share your information with other people. Similarly, an IP assignment agreement. If you have a business where people are going to be creating things, let's say you're a budding musician and you're working with other collaborators, and you're in the studio late at night and you're working on a song, and somebody you're working with, they come up with some bars or some lyrics. If you don't have an agreement with them that says anything they do when they're working with you, they're assigning to you as an owner, you may have a problem and not have rights in that. Next slide, please. So a lot of these IP issues we all see publicly on social media, and I just was going to briefly talk about some recent ones that have been in the news. So one is Nicki Minaj versus Tracy Chapman. Nicki Minaj, obviously a current very popular hip hop artist. Tracy Chapman, an equally successful singer in her own rights many years ago. So Nicki Minaj prepared a demo version of one of Tracy Chapman's songs. She actually didn't release it publicly. The copyright owner has the exclusive right to perform their work. So nobody can perform that work unless you give them permission. But what Nicki did do is she gave it to a popular New York City DJ, and that DJ played it. Tracy Chapman sued her, and they ended up settling the case for $450,000, even though Nicki Minaj had some defenses potentially, but she decided to settle that case. Another example that just happened this month is there is a photographer that took a photograph of Miles Davis. It's a fairly iconic photo. And celebrity tattoo artist Kat Von D, she has, not only did she tattoo that image on a customer, but she actually posted photographs on social media of both the photo of her tattoo, and she is now being sued by this photographer because that photographer has the right to display that photo. And also the copyright owner owns the right to make derivative works. And a derivative work is when you have an existing work like the photo, and then now she's making a tattoo. Or for example, if you've read a novel and it's made into a screenplay, that's a derivative work because even though the movie is different, it derives from the content of your novel. So the other thing about copyright is you are a small player when you're a small business potentially compared to if you were a big corporation, but statutory copyright infringement damages are $150,000 per work. So for example, if this photographer prevails in his lawsuit against Kat Von D, he can receive $150,000 for every time that she tattooed someone and displayed it, every photo that she's posted on social media, plus the profits she gained and the losses that the photographer incurred from license fees that he could have gotten to license that photograph for tattoo purposes. So if you use social media in your business, there's a few key takeaways you need to have is avoid posting content that you did not create. If you're going to post something that you didn't create, make sure you obtain permission from the author or the content owner to post their content. And giving credit is not always enough. So you can't take it, post it, and say, credit it to Washington Post, and you didn't ask Washington Post, can you repost that? Do not assume that the fair use defense will cover you. Mauricia is going to talk a little bit about fair use after me. And another big thing is you can carry insurance that covers you. So sometimes you may accidentally post something that actually was someone else's content and you didn't realize it, or maybe you thought that you had a right to use it. Maybe you thought it was already in the public domain. There is insurance, general liability, commercial general liability insurance that has advertising industry, and it will cover the accidental use of third-party content. It likely won't cover if you intentionally, willfully use somebody's IP, meaning you take their content on purpose, but if it's accidental, you can have insurance coverage. The other thing is to beware of trolls. And what trolls are basically companies and law firms that they make their whole business going around looking for people who are violating intellectual property licenses and rights. And when you're a small business, even these small amounts can put you back when you're trying to get your start. So for example, they may send you a letter, and that's called a demand letter. And they say, you're using this image that's, from my client's website. And what they do is they actually acquire rights from people. So they might not even be the copyright owner, but they acquire the right to sue on behalf of these owners. And they'll say, pay me $8,000. And, it costs a lot to defend a lawsuit. So you may have to settle for $3,000. But if you're just starting your business, $3,000 can be a big hit to you. $1,000 could be a big hit when you're first starting a business. So when you are doing things on social media, there's a chance that nothing will happen. But as your popularity grows and your success grows, there's a big chance that you could pay for mistakes you make early on if you don't think about these things. Next slide, please. So we're enjoying our last few days of celebrating Black accomplishments and educating people about the accomplishments of Black Americans in the United States. So here's a little copyright story in honor of Black History Month. So we've all heard the iconic "I Have a Dream" speech. It's one of the best sentences that we probably hear growing up and throughout our lives is "I have a dream" and being judged on the content of our character. But how often do you ever hear that entire speech and not just excerpts? So the reason why you often don't hear the entire speech and you only hear essentially, we've reduced this iconic speech full of powerful imagery and a message to just "I have a dream" is because the speech is protected by copyright and it's not in the public domain. And the public domain means when something is just not protected by any legal right and anybody can use it freely. And so when you do hear the whole speech in its entirety, that TV network has obtained a license. And it's not only Dr. King's estate that has enforced this license, but shortly after he gave the speech in August 1963, he moved to get a preliminary injunction against record companies, and it was 20th Century at the time, from selling copies of his speech. And a lot of you have probably seen the movie Selma, which was a beautiful retelling of the march on the Pettus Bridge. So you may have noticed that during that film, King's speeches didn't sound like how you remember when you've read them or studied them or heard them. And that's because the King estate had already licensed the right to use the King speeches in film. So when you own a copyright or you own intellectual property, you can give somebody the right to only use it for one thing. So the King estate said for film, Steven Spielberg has the right to use the speeches exclusively. So you can give a non-exclusive license, meaning you can give that license. So when you have Microsoft Outlook, you have a non-exclusive license because millions of people have Microsoft across the world. But an exclusive license is when you're telling somebody they're the only one who can use it. So Steven Spielberg was the only one that had the right to use the speeches. So Ava DuVernay had to do a pivot and make it work by only paraphrasing. So under the current law, King's speech will be protected to 2058. And I know for probably a lot of us on here, you know, we probably were born after Dr. King was tragically assassinated. So that's the power of copyright, that it lasts, you know, for generations. We talk a lot about generational wealth. So your intellectual property is really something that has value beyond your lifetime. Thank you.
Well, thank you so very much, Jennifer, and especially for that very comprehensive insight into trademarks. As you can see, trademarks are very, very important for a business owner to consider at all times, whether it be protecting your own mark or whether it be being sure that you don't infringe on the trademark or the IP rights of others. And just one important point to note, which I thought was really great, that Jennifer really touched on. You know, it really can impact your business greatly if you're just starting out, whether it's $1,000 or $3,000 or what have you. And what I've seen just in my experience, a small infringement to you, or what may seem like a small little just a infringement that, you know, you think you might just get a warning or slap on the hand for, could wind up costing you thousands of dollars, and for something that maybe you didn't even profit nearly as much on, you know. And what happens is that you know, that IP rights owner has valued that infringement maybe more so than what you contemplated. So, you know, that's really an important point to note. So when in doubt, you know, consult the advice of a professional and really take a lot of these points in consideration. So thank you very much for that presentation. We are going to try to move along just a bit quickly. We have 2 more segments to cover in our IP portion of this presentation. And next we have Marisha Bay-Taylor, who is going to touch on some additional points regarding internet and social media. And I bring you Marisha.
Thanks so much. So I'm just waiting for my slides here. So the first thing I wanted to kind of pivot us back into the world of trademarks and filing for your trademarks. And, you know, there are a number of things that can happen. We all hope that, you know, when we file our trademarks, they proceed smoothly into registration. We get that fancy certificate and we're good in the clear. Unfortunately, it doesn't always work like that. Sometimes there are office actions that arise in the course and scope of trying to obtain your trademark. And these are issued by the USPTO. As you all know, when you file the trademark application, it goes to the USPTO where it is assigned its own examining attorney. So they have their own attorneys there and they go through each application with a fine-tooth comb. So those attorneys are really there to see if there's any other potential marks that could be confusing, anything else out there in the market that could be in conflict with you, and really vetting those marks to see if they're eligible for trademark registration. So there are a number of pitfalls that can come up in the course of that. Number one is you can receive a merely ornamental refusal. So what does that mean? I get a lot of clients that come to me, you know, with a particular phrase they've put on a t-shirt, such as "my melanin is magic." And they say, "Mo, I have this amazing t-shirt, this amazing phrase. I'm ready for my trademark." And all they can produce is this t-shirt with that phrase on it. So that is likely to cause a merely ornamental refusal, because what trademarks are really looking to trace is what is the source of the goods or the service? What is the brand? So as you see there in that image, we see a t-shirt with just a phrase on it, and that is, again, likely going to cause this merely ornamental refusal where they can't pinpoint, well, what is the source of this phrase, of this image? What we're really looking for is something that will attach that phrase to a brand. And that's what you want to trademark as your brand. So as you see there, when it's attached to like a tag or a collar, something that is often associated with the source of the goods, that's kind of how we can get around some of those merely ornamental refusals. So if you have a clever phrase, what you really want to do is create a brand around that and have multiple products that have "My Melanin is Magic," shoes, t-shirts, and really have that as a source of a brand versus just a one-off on a t-shirt. Another pitfall that can happen is that the examiners may find that the trademark is merely descriptive. So I've seen this, for example, if you have something that is too closely tied to what the product actually does. For example, if you have a 3XL t-shirt and you want to trademark that, that's likely to cause a merely descriptive refusal. That trademark is merely describing what it is your product is. So creativity and uniqueness is always important when you're looking to trademark and get that through the trademark office. Lastly but not least is the likelihood of confusion. And that happens where you have other, existing trademarks that are too closely tied to what the name of your brand is. And there's no real clear rule, how close things could be. And that's what Caleb mentioned, it's very important that there's a clearance search performed and you're using different derivatives of the brand name you have. Some people say that even a 25% similarity in name can cause a refusal. So that's a good measure, but again, there's no bright line rule, but you want to make sure you're being unique and creative in that space as you brand your company or your good or service. Next slide there. So then transitioning, I want to talk about the fair use doctrine. This is a huge question I get a lot in my practice. I work with a lot of just creative people that are making various products, and they're often borrowing from other existing pieces of work, whether it's like a photo and they want to incorporate that into like a tarot deck. It becomes a matter of, how much can I borrow? What can I sample? What can I do? And it really boils down to this fair use analysis. And again, this is no bright line rule. This is really going to be determined on a case-to-case basis, and it's all over the place. But these are the factors to keep in mind. If you really have to, sample something from someone else and you don't have their permission, or, there's something you really want to use and incorporate into your work, you don't have that permission, because again, this is going to be a defense. It doesn't mean that you haven't infringed upon someone's copyright, because more than likely you have, but this is the defense in case you were ever held into court. What would the court be looking at in terms of if your usage was fair and just and in the clear in that sense? So the first thing we want to look at is, what is the purpose of your use? Are you using this in a commercial sense, or are you using this more in like a nonprofit educational sense? When we get obviously more into that more educational arena, that's where we're going to be the safest. Looking at the elements of that, like how are you using this? Is it for a criticism or parody, news reporting, teaching, research, more of those academic kind of uses? Those are going to put you more into the fair use category, where the court is likely to determine that your infringement was fair and just. Next is, are you transforming? And that's something I always tell my clients as well. Like, okay, if we're going to use this image, it's important that you kind of make it your own. transform it a bit, add some embellishments. I have a client, that adds gold kind of emblems to her various uses of historic photos. She kind of makes them her own. And it gets us further into that fair use category, and keeping that work safe. The next thing I'm going to look at is the nature of the copyrighted work. This is the work you're borrowing from. So the court is more likely to rule against you if you have sampled or used a work that was unpublished. Typically, the copyright holder is who has the right to publication, meaning releasing that into the public, into the world. So if you've gone and taken that liberty yourself, that's going to be shunned, and you're going to be likely on the hook for copyright infringement. So, this kind of gets us into works that are a little more popular. If there's things that are kind of everywhere, then that's already published. If you're transforming them, then you're likely to get, a fair use, a green light on the fair use determination. Next is the amount and substantiality of the copyright material used. So this is definitely a balancing act. It's not always what it seems. Sometimes, it's not the quantity that matters. Sometimes it's that one line that is the most important part of, say, a song. I don't know if you guys have recently watched Vice News. There's a really popular special right now on Cisco and the thong song. And he said, he got the thong song, he got the violinist, everything was running smoothly. And then he hears from Ricky Martin's people on the Livin' La Vida Loca line. And he had to, he didn't initially get the clearances for that or the permission. So if we were in a fair use kind of analysis on that particular instance, then again, it's not like he sampled the entire song, but Livin' La Vida Loca is the most popular part of that song and that phrase. So likely a fair use, he wouldn't be able to get a fair use defense on that particular use. And that's probably why he went ahead and paid them eventually and avoided litigation in that sense. Last but not least is the effect on the potential market for the value of the copyrighted work. So what this is really looking at is, how did you affect the value of that work? Are you, with your use, taking away from what the marketability of that copyrighted work could be? Also, the court is likely to find you on the hook for copyright infringement if you could have easily went and got a license for that work. If that was accessible and that was out there, then this is going to go against you in terms of fair use. If it's there, you should get it. That's what I always advise my clients to do. Okay, we can go to next slide. So I want to talk about takedown notices, and that's kind of like, okay, say you're on the other side of this equation and you see someone on YouTube has sampled your work without your permission. How do you go about getting that stuff taken down? So in accordance with the Digital Millennial Copyright Act, each social media platform has a takedown procedure. YouTube has it, Twitter has it, Facebook, Instagram, Yelp. All of these different entities have steps in which you can go to submit to have something removed. So some of the common statements they'll want you to attest to if you are looking to have something removed is that this is not an authorized use of the copyright, that you are in fact the copyright owner. So typically with my clients, I will file to register. If say it's a video, maybe something they made from TikTok that's being used without their permission on YouTube, we'll file the copyright, have that registered, and therefore we can demonstrate that we are in fact the owners of that copyright and petition to have it removed with these takedown procedures. Lastly, it's important that if you are using these tools that you are using them rightfully. Frivolous claims are not taken lightly, and they can result in an account termination and closure. So make sure, and that's again why I usually will go through and register the copyright, the video, the song, the artwork, whatever it may be, to make sure we are in fact, the legal owners, and then we are having that taken down. This is not running the risk of having any kind of accounts terminated or anything like that. Very lastly, next slide, please. So another popular thing that kind of arises when we're talking about takedown notices is the world of Yelp. We all know about that angry customer that runs straight to Yelp and they're just letting it all out. That's where they air their grievances. And as a small business owner, you may not agree. Someone may be overreaching, fabricating, just telling downright lies about your business. And it's important to know there are certain procedures to go about having those things taken down. Yelp is kind of open source, and they usually do stand by their reviews. They're not one to take side with the particular legitimacy of a review. But if you do have a judgment by a court, you could always take that to them, and that's going to be the quickest way to get that defamatory review removed, is making sure you have a judgment from a court, or your lawyer does, and then petitioning to have that removed. Entities like Yelp also have automated software that is constantly kind of monitoring reviews to see if they're useful or not. And sometimes that can result in a takedown just kind of on its own if Yelp itself finds that it's just not a very useful review. So that is about it. It's been a pleasure. Thank you all for having me. Those are my social media. If anybody wants to connect, I love connecting with new people, especially new clients. So feel free to reach out to me on any number of those platforms.
Thank you so very much, Marisha, for that presentation. And again, as we can all see, just in general, how important it is to protect our intellectual property, because it can have an impact on the business. Also, exercising whatever remedies that there are under the law are equally important, because that can have an impact, as you can see, on your business. So in the interest of time, we're going to move quickly to our last portion of the IP segment. And we're going to bring Caleb Green back to the floor just to talk a little bit about enforcement.
Sure thing.
Protecting your IP, as we see that it is critical, because IP is an important asset for every business, and it's extremely important. I've been saying that, and I can't say that enough, for you to protect your property. So, Caleb.
Thank you, and I can't agree more. We talked a lot about how to get and secure your intellectual property. It also makes sense for you to understand how to enforce it. Just like Ms. Bay Taylor had mentioned, DMCA takedown notices, many of the social media, Amazon, these online retailers typically will have a takedown notice form in process. So you do want to take advantage of that. That can be very useful into getting certain products removed that are infringing on your particular rights. You also can expand it a little bit outside to the terms and conditions of each website. So if there's something that's misleading, but it may not necessarily fall squarely under intellectual property infringement, you can also use their own conditions in terms of use and service. I'm going to run through a couple of these just very briefly. Cease and desist letters can be very helpful in enforcing without having to go to litigation. These are your standard demand letters that an attorney can draft, and basically lays out, these are my rights. Here's how you're infringing on my intellectual property rights. And please stop by such and such date, or I'm going to file legal action against you. Those can be very helpful and oftentimes can stop people from infringing. You don't have to spend time on going to court. UDRP, the Uniform Domain Name Resolution Policy, is also another way to enforce your rights. This is more related to domain names. And if you have a trademark in a particular name and someone is using that in a way that is confusingly similar to your mark, then what you can do is you can go through this process and actually get that domain name transferred over to you. So that is another option. Two more I'll just highlight on. We talked about NDAs and non-competes. The CASE Act creates a copyright small claims court. You may remember the $600 that came with the last COVID-19 bill. That bill was an omnibus bill, and it also included this creation of a small claims copyright court, where it essentially allows copyright owners to bring claims against infringers as long as there's not seeking damages in excess of $30,000. So that is something to keep in mind. The last thing I'll talk about is the U.S. Customs and Border Patrol, which can also be a very useful tool. If you have a copyright registration or a trademark registration, you can record those registrations with U.S. Customs and Border Patrol. And what they will do is when goods are imported into the United States at the port, if they find something that is confusingly similar or infringing on your rights, they will seize it there and it will not go further throughout the United States. It will not be imported. So those are just a few ways that you can provide any forms of enforcement to your intellectual property rights.
Thank you, Caleb. You mentioned a cease and desist. And for some business owners or a person in the creative industries, when they receive a cease and desist, sometimes they get very, very anxious naturally. And so maybe the tendency is to not answer it, not do anything. Or maybe they get a letter from a lawyer that says, hey, look, you infringed upon my mark, contact me, and, so that we can settle this. And they ignore it and they just say, well, I stopped. And then they get a lawsuit or get a complaint in the mail. Just talk a little bit about the idea of perhaps being off the hook or for infringement versus just stopping further infringement, and how that impacts liability or potential liability?
Sure. No, definitely. Yeah, you definitely want to respond. IP is strict liability, which means it doesn't matter if you intended, doesn't matter what your intentions are, maybe for damages. But as far as infringement is concerned, it's, just like speeding. If you're 1 mile over, you're speeding. If you're at the speed limit or below, then you're not. It's pretty black and white. So you definitely want to respond. And you may, in some cases, want to get a settlement agreement, a mutual release agreement in place that actually puts it in writing. Hey, we're both parties are are releasing any claims they have. We're settling this just by merely if you're going to pay money, that's the agreement, or if it's just ceasing to sell certain goods. You just want to make sure that those contracts are crafted very carefully. Many cases, sometimes you can have a client or a settlement agreement where you are agreeing to cease selling any confusingly similar goods or anything that infringes, but the contract may only say you're only going to stop selling, these specific unauthorized goods. You want to make sure that it's also, you're using language such as permanent or in perpetuity. So it's not just this one instance. You're not going to have additional infringements in the future by the same party. So those are just things to keep in mind when it comes to responding to a cease and desist. Don't just respond, don't ignore it. Don't just respond, but you also may want to think about getting a mutual release and settlement agreement as well.
Thank you.
Question. Oh, I'm sorry. I have a question on the cease and desist. When you do the cease and desist letters, do you have them with a great deal of detail or specificity, or do you keep them broad?
For me, it depends. So most of the time, I'm pretty specific. I'll cite, if we have a trademark registration, here's a list of our trademark registrations and the rights. If it's a copyright registration, here's our copyright, or if it's an application I just filed. And then I'll go into detail about how long they've been using this. And then I'll specifically draw the contrast of its copyright infringement. Here's why these are substantially similar or exact copies. If it's a trademark, this is why this is confusingly similar. And sometimes we've gone as far as listing all of the factors and addressing it in there and saying the goods are similar. The name, it looks the same in sight. It sounds the same. So a lot of times, I think the strongest cease and desist letters are the ones that are effectively in detail. So I think the more detail, the better in some cases. It does depend. Sometimes we have a little bit more of a challenge, and we might make it a little bit more broad versus specifying it. But for the most part, I think specifying in detail exactly what they're doing wrong is the best way to motivate them to stop.
Thank you.
Of course.
Can I just say something, Vice President Dominique Calhoun?
Oh,
Madam President, I'll always defer to you. Yes, ma'am.
First of all, I want to thank you for the extraordinary work, the tremendous work that you've done. I want to thank our board member Grant as well for the work, for moderating this. And I'm not suggesting that the panel's over. I just have to remember to do this because I started at 5 o'clock this morning. It's in my notes of comments to make, so that I don't leave here without thanking you for not just your work here, but the extraordinary work you do on the Board of Governors. And just let you know that everyone here should know the fine work that you do all the time, showing up and being there for the National Bar Association. And I also want to recognize our interim executive director, Maurice Foster, and thank him for all the work that he does day in and day out. And I know that sometimes we are very demanding and request a lot of you, but I just wanted to publicly thank you all again and let you know how much we do appreciate you. And for those of you who may not be on the Board of Governors, you should know that they show up every time and they're doing the work of the National Bar Association and doing a great job at it. So just thank you all.
Well, Madam President, we greatly appreciate it. Thank you for joining us tonight. This all would not have been possible without the contributions of Wells Fargo. And we mentioned it before in the program. We alluded to it when Jennifer spoke, and she was talking about the issues of IP. We talked about this program serving as an opportunity for you to maximize your finances. And even in the chat, I told you that what we are doing here as the National Bar Association is we are giving you the tools. We are lending our experts to you all in the public to make sure that you have the ability to scale up your business, protect your assets, protect your brand. But this all would not have been possible without a couple of years ago, a sponsorship coming on from Wells Fargo. And equally in part with this discussion, when you talk about maximizing your finances, you're going to inevitably work with a bank. You're inevitably going to look to scale. And so we have one of our foremost experts from Wells Fargo that has joined us here today. Andre Jones is out of Philadelphia. For all my Texans, he is a Giants fan. We talked about that earlier. I guess it's better than being a Philadelphia Eagle fan, but hey, I'm a Cowboy fan all day long. So Andre, we appreciate you being here. We thank Wells Fargo for your contributions. I'm going to turn it over to you. Again, thank you all for joining us. But Andre, let's talk about the issues that you may experience when you are trying to scale up or moving forward in your banking with your business and the things you need to be looking at.
Absolutely. Thank you so very much, VP Calhoun. Thank you, Madam President. And just on behalf of the Wells Fargo organization, we just like to take this time to say thank you so much to the NBA leadership and to its members and amazing members. And Wells Fargo is excited not only just to take part in this amazing event, but also to be a sponsor of this awesome, amazing event. So just want to say a quick thank you again for this opportunity. Thank you so much. Tonight, I'm going to be briefly just discussing one of a small business's favorite topics when it comes to business is small business lending. And so I want to dive right into this on how important small business lending is, and really it's the heartbeat of a business growing. And so there's three parts that we want to cover tonight. Small business lending overall, talking about what that looks like, the importance of your credit, and how to really make sure that you are putting your business in the right position in order to become what I call bankable or lendable from a banking perspective. And also looking at what is SBA lending. A lot of people hear about SBA, especially when it comes to the PPP. And we want to talk a little bit about what the SBA does and how Wells Fargo works with the SBA to make sure that we are make sure money is flowing through our communities. And also we'll take a quick glimpse at the Paycheck Protection Program. So you can go to the next slide, please. One more slide over. Yeah, thank you so much. So when we look at credit, especially for a business, we've heard this terminology before, looking at the 5 C's of credit. It's credit 101, but it is so important. And as I talk to clients on a daily basis in my current role at the bank as a small business strategist for the bank, I'm constantly talking to clients about the importance of making sure they're managing these 5 C's very efficiently, very effectively. And so the first one is your credit history. And credit history pretty much lets us know what your past action has been as far as how you have managed your past obligations when it comes to your lending habits. And so this tells the bank, this gives a snapshot, because obviously we're not there, but we get a snapshot of your ability to manage credit, to pay back on time, to make sure that you're not overutilizing your credit. And so that credit history is really, really so important. So I always tell businesses to make sure that they're managing that properly, because for a bank, it tells us also what we should expect in the future if we decide to lend to that particular business. The other C, which is really important, is the collateral. Collateral is really, really critical, and really pretty much just to sum it up, when we look at what collateral is just the assets that may offer a backup source of repayment to the bank. And so if you're looking to, real estate would be a great example. If you've ever got a commercial mortgage, you go get a mortgage for the property, and the bank uses that property as collateral in the event that there's a default or something like that. So collateral is really important. Collateral can also come in the form of other investments. And so there are some businesses that when it comes, they may need to cross-collateralize. In other words, they may not have the strength of the credit just yet to get the loan, but if they have other assets, the bank many times will look at other things that they can collateralize just to kind of as a backup of a source of repayment. It's so important as well. Then we look at the third C of the 5 C's of credit is capital. Capital is really critical. Capital is pretty much your own personal investment in the business. And so you want to make sure that if you're going to get any kind of lending from the bank, that you're not going on zero pretty much. You don't want to go to the gas station when you're actually on E, right? You want to get there before you get to E, right? So we want to see that there is some liquidity, that you have a relationship with the bank, that you have healthy deposits, whether it's in savings or your checking account, it doesn't make a difference. But we want to see that there's some kind of ability to pay it back just based upon your capital that you have. In this current lending environment, banks really at this point like to see that if you want to lend a certain amount line of credit, that there's 25 to 30% of liquidity that you have available in your accounts, sometimes more depending on the type of lending, which we're going to talk about in a moment, in your accounts, just makes the bank feel more comfortable. So that's really, really important to make sure that you have some kind of capital. The fourth one is conditions. And this is really speaks to kind of where we are now in our current lending environment with COVID, and we're just in unprecedented times. And so the conditions, when we talk about conditions, it's just what's the environment of the business, your ability to repay the loan, what's your thought process, what is the really, we call it the lending cause. And so some businesses want to borrow money, but there's no true lending cause. What is that capital, that money going to be used to do? Is it going to be used to grow your business? Are you looking to expand the business? Are you trying to get into a market that maybe you were not in before? Are you looking to hire new people? What's your plan? How are you looking to do that? Because that also feeds into the last C, which really is capacity, right? What is your capacity to repay this loan? And so that's really, really, really important. What do you project, your projections sometimes, especially with the SBA, which we'll talk about in a moment, they definitely look at your 3 to 5 year projections. So if you are expanding a business, you're starting a business, or you want to add a new arm to the business, they want to know what your projections are. What is your capacity? How are you going to bring in that business? What's the plan? And sometimes, especially with the SBA, they'll also ask for a business plan to make sure that you have thought it through, you understand it, because we want you to succeed just as much as you do. Go to the next slide, please. Awesome. Thank you so much. And so, and when we look at some of the options, what are some of the small business credit options? I love to go over this with clients because, you know, there's more than one way, as they used to say, to skin a cat. And so you have multiple options when it comes to lending, right? So the easiest, I say, way to put your toe in the water, if you're a new business, you're just getting started, you don't have much of a credit history, it's always easy to start with a credit card. And so some of these other products we'll talk about or solutions, you may need to have been established business, but when it comes to credit cards, you can open up your accounts today and you can apply tomorrow for a business credit card. And this is a good way to kind of get your toe in the water, learn how to manage credit. I always encourage my business owners to make sure that you don't leave a lot of debt sitting on those credit cards because they'll hike up your utilization rate, and you don't want to have a high utilization rate on your business credit card. So credit card is a great way to get introduced to some kind of business lending. Also, with Wells Fargo, there's rewards on the cards as well. So I know a lot of business owners that run a lot of things through the credit cards. They reap the rewards, and they can use those rewards also to help get things for the business. Lines of credit are also very important. Those are normally for emergencies or if you want to kind of fill what we call cash flow gaps. I'm gonna go into too much detail, but cash flow gaps. So I have a client, for instance, he is an exporter and importer, and he exports things overseas, but there's a major cash flow gap because by the time that product goes out and he gets paid on it, there's gaps and orders come in, he can't fulfill those orders. And so we look to give him a line of credit in order to fulfill those cash flow gaps, that as this money kind of makes its way around the globe, by the time it comes back, he doesn't have to sit there and wait for that money to hit his account. We can fund him through those lines of credit. And again, lines of credit are also to make sure that you are not letting debt sit on those lines. Okay, you want to keep those revolving lines of credit, and the bank looks at how you use that. So some clients, you know, they get the line and the debt sits in there for 2-3 years, and that's really not the purpose of what a line of credit is for. It's to use it, put it back, use it, put it back. And when you see that, when the bank sees that, then believe me, it goes a long way. Then you have term loans. Term loans is where debt sits, right? So if you want to purchase equipment, that would be a term loan. So I have some clients that say, you know what, Andre, you know, we need to get all new equipment. Our equipment's old. We need to update the equipment. We're a manufacturer. Great. Then we're not going to give you a line of credit for that. We're going to make sure that you have a term loan. And being able to use these tools, I always call these tools properly, is really, really a big difference. Then you have business real estate finance, or what we call it Wells Fargo BREF. It's a BREF product. So if you're looking to buy any commercial properties, commercial is any building that has more than 4 units is considered commercial, or it's mixed use. So there may be a store on the front, on the first floor, maybe you have 1 or 2 units upstairs. That could be a commercial use. And so with our BREF product, it's really, really extensive. We'll lend up to $1 million for property. Of course, has to have an appraisal and make sure that everything, all the numbers make sense. But also BREF is a really popular product with the bank. Then there's letter of credit. And that's really important, again, for those who may be in export and import business. Sometimes you go out there and you're dealing with a new shipper, and they may want to make sure that you're credit worthy with the bank. We will offer a letter of credit to our clients to show to people that they may be trying to get a shipment from one part of the country and they don't want to release any cash. Well, you can say, hey, I have a letter of credit from Wells Fargo, and we back up that letter of credit. So that's really, really important depending on what kind of business that you're in. Practice finance is another big, huge credit option, and that's pretty much anything in the healthcare space. So if you have a business that may be a dentist, or you may be a veterinarian, or you may be an optometrist, you know, whatever it is, that practice finance space is really a big piece of what Wells Fargo does. So we'll fund a practice almost up to 100% of an acquisition. So if they're looking to purchase an existing practice, we'll pretty much almost give them 100% of the funds of the practice to purchase that practice. If they're looking to start up a practice from the ground up, we'll also look at financing them as close to the 100% as we can. So that's a space that Wells Fargo plays very well in when it comes to the practice finance space. Also includes chiropractors as well, and MDs as well. And lastly is the small business administration. We're going to talk a little bit more about them, go a little bit deep into the SBA, But again, Wells Fargo is one of the largest SBA lenders in the country. And we're very proud to say that we have the opportunity to help millions of small businesses across the country on a daily basis. And that's really something that we do very well. If you can go to the next 2 slides. Awesome, thank you so much. And so just a quick overview of some of the highlights of the SBA. SBA's mission is to help business owners grow and to thrive. Their lending provides access to capital for borrowers that may not be able to obtain reasonable terms and conditions. And also, business of all sizes. So no matter what size your business is, the SBA is there to help. And we partner, of course, with the SBA to make sure that we're reaching the community and helping these businesses grow and expand. And just so you can get an idea of what kind of loans the SBA does, if it's expanding a business, we can help you do that. I'm currently helping a client that has several supermarkets, and he's looking to purchase another supermarket, and that's going to be through SBA. And so because he's shown that he has proof that he has a business model that works, we're in the process of getting him approved for this 3rd location. And so if it's business expansion, no matter what it is, SBA is a phenomenal tool to use for expansion. Also, purchase of real estate and equipment, kind of went over that already. You can use SBA if it comes to purchasing. They will not do investment properties. So if it's investment properties, they won't do, or we call IREs, investment real estate, but they will do business occupied real estate and also equipment. So if you're starting a business or you're expanding that business and you also need equipment with that business, SBA will not only fund the purchase of the building, but they'll also fund the furnishing and the build out of that property as well. Also buying a business. If you want to acquire a business, you say, hey, I want to buy even franchises. There's some franchises that are what we call on the top of the list for the SBA that they'll definitely say, hey, we'll fund that close to 100% as well. And so if there's a franchise or a business acquisition, I just finished one not too long ago for a client who brought a brewery here in Philadelphia, and it was an acquisition. The owner was retiring. This gentleman had business background. He came in and he brought the business, and then also various other purposes as well. You go to the next slide for me, please. And I'd like to end on the PPP, which is a big push right now. We all know the pain that a lot of businesses across the country are experiencing. The great thing is that I read a recent poll that businesses right now are really optimistic. And, you know, I'm so thankful to be a part of Wells Fargo to really see how we're helping small businesses literally on a daily basis. I had the opportunity to be part of the PPP team when it initially rolled out. And the 19th of January, we launched the 2nd round of PPP, as you all know, was approved. And so I definitely want to encourage you, if you're a small business, to the website that's on the screen, definitely jot that website down. There's a ton of information there that Wells Fargo has made available on the 2nd round of the PPP. And also, as you all know, as you get that loan, there's certain conditions that need to be met that that loan may also be forgiven. And so just want to thank you so much for giving me the opportunity to come and to present. And if you want more information, you can go to our website at wellsfargoworks.com. And there is a ton of small business information at wellsfargoworks.com. Thank you so much, Vice Chairman.
Thank you, Brother Jones. And I want to thank everyone, all of our panelists, for being here tonight. You all have provided a wealth of information from your respective areas of practice. And I'm sure the folks that have joined tonight and those who will review later will find the wealth of knowledge that's been given to be extremely helpful and resourceful. For anyone that's watching the program now and you still have further questions, or you may go back and review it, feel free to send all of your questions. I'll take the liberty to do this now, and then we'll forward it on to the members at vpmembership@nationalbar.org. So that's vpmembership@nationalbar.org. Before I wrap up, President Hoffler, do you have any other closing remarks? I see she may still be on, and if she's not, we'll move forward. But or Executive Director Foster, I think I saw you here as well. If you have any remarks. All right. Well, if not, I want to thank our panelists, Genya Grant, Shantia Colley, and Jennifer Fisher for serving on the Economic Empowerment Institute Committee and this subcommittee to help put this forward. Marisha, Caleb, and Shahara, I want to thank you all for being here as well. This was an excellent program. This is the first installment that we have. We will continue to provide this program, and the next one that we'll do will be next month. It will be the 4th Thursday at 7 o'clock Central. And at that time, we'll be talking about consumer rights. So come back, see us again. We'll talk about how to protect your own assets rather than business focused, but your own assets. And again, we'll have a brand new host of panelists that will help us do that. And again, I want to thank Wells Fargo. I want to thank all of our panelists for being here tonight. And I want to wish you all a good evening. Thank you all for being here. Take care.